welcome to another show of the future of Europe. We have Chloé here today, going to discuss international protection for minors with parents that already benefit from it in the case Roe versus Bundesrepublik.
Yes, exactly.
Yeah.
Thank you for having me here today.
Thank you. So my first question is, what is international protection and how are children especially affected?
I just wanted to start with a quick figure so that you understand. According to Eurostat, since the beginning of the Ukrainian war, more than 4.2 million Ukrainian refugees, came into the EU, and 2/3 of those were children. So the EU in such conflicts aims at establishing a safe and stable regime for refugees, children, but also to protect the member states' interests. And to answer to your question, international protection is the action by the international community under international law to safeguard fundamental rights to certain people that in their own country are not possible.
Okay.
And that, started with the Geneva Convention, and children are especially affected by it because, as you may know, in most legal systems, they have limited legal capacity and are often very dependent of their parents.
Okay, and despite these efforts, how does this case assess the difficulty of assessing international protection for minors?
Yeah, so just to give you the facts of the case, this concerned a Russian family that came to Poland to have international protection where they received it, but a couple years later they moved to Germany and wanted to have international protection there. However, Germany refused because under EU law, you can only have international protection in one country, not two. But however, a couple years later, the applicant was born in Germany, and her family wanted to have international protection there. But the German authorities refused because of her family already having international protection in Poland. So the family challenged this, and the referring court asked the ECJ through a preliminary ruling whether or not, under Dublin III regulation, the minor's application for international protection could be regarded under the same terms as her parents'. And actually, the first question was whether or not Article 20.3 could be applicable. And Article 20.3 of the Dublin regulation states that when a minor is with an applicant that is a family member, they have to be in the same country. They're undissociable. But as you may have heard, that only concerns applicants and not beneficiaries. And here, the family has already international protection. So there's a risk, according to the court, that the minor would become a refugee in orbit.
Okay, and why would you say that?
I would say that because if the minor is in the country without going through the legal procedures and the parents don't go through them either, the country would not be aware of him and would not be able to take care of that child. That is why I would say that.
Okay, but how does the court determine the competent country?
So there's an article in the Dublin regulation, again, Article 9, that deals with the case of family members, parents being already beneficiaries. But there needs to be a condition of express consent for the child to have his application heard in the same country. However, here, it's not the case. The minor and the family don't want the child to have its application be heard in Poland. So in that case, it's actually the first country in which the minor applies that is responsible for studying that application.
Okay, but can Germany consider the minor's application for international protection inadmissible?
Well, that's what the German courts wanted to do at first because they used Article 33.2 of the Directive 2013/32. That doesn't really mean much to you, but it's the situations in which a country can refuse international protection. And the first reason is, like I said, not wanting to grant twice international protection because in the EU, there's mutual trust between countries, like in the case Commissaire aux réfugiés et aux apatrides, and you can only have international protection once. So that applies only to the family, not to the child, because That's what we call rationa personae. And when the family had their status in Germany refused, the minor was not even born. So it's not logical to refuse that application under that terms.
Okay, and how has the notion of the child's best interest become a safeguard principle?
So a safeguard principle is a principle that aims to protect, here, for example, children from any damage or harm by having appropriate measures. And that's what the European Court of Human Rights and the ECJ aim to do. The notion of the child's best interest first arrived in European case law in 2006. And it was first linked to private life and family life. However, after 2010, it became more about family reunification. Now there is even a presumption that the child's best interest is always with their family. That's from a case MA and others from 2019. However, it's quite original here because in this case, the child's best interest is never mentioned explicitly. The court favors technical solutions, I guess, to assess an effective right to international protection, but by studying other things like social economic rights and also the child's perspective.
Okay, and does the ECG face problems in applying that principle?
Yes, and I would say it's not only the only court that does, because according to some authors like Jenny Edlin and Vaclav Stelkik, they said that in immigration law, the protection offered by the European Court of Human Rights is actually currently at its weakest. And I would say that the ECJ faces two problems. The first problem is that European countries, there are 27 countries in the EU, and they each have their own policies, and especially towards immigration. And some countries are becoming more and more hostile to them, like Italy, for example. So that is the first big issue. The second issue is that children are not the only vulnerable group in the EU or in migrations. The ECJ cannot always favor the child's best interests. There are also, for example, climate refugees that are going to be more and more important in the future years. So that's what the future of Europe is going to be balanced with: national member state interests and also other vulnerable groups.
Okay, thank you. I have no more questions. Thank you for this very interesting discussion, and see you soon in another show of the future of Europe.
Thank you.